नमस्ते फ्रेंड, आप सबका एक बार फिर से स्वागत। और फ्रेंड्स, आज बात करते हैं एक बैंकर्स केस की। एएम कुलश्रेष्ठ वर्सेस यूनियन बैंक ऑफ इंडिया। सुप्रीम कोर्ट ग्रांट्स रिटायरल बेनिफिट्स टू बैंक एम्प्लॉइज, क्वेसेस डिसिप्लिनरी प्रोसीडिंग्स। सुप्रीम कोर्ट ने ये आदेश किया कि रिटायर्ड एम्प्लॉय को जो भी रिटायरल बेनिफिट है उसको दिया जाए और जो भी डिसिप्लिनरी प्रोसीडिंग्स है उसको उसने क्वैश कर दिया। जानते हैं कि पूरी बात क्या है, पूरा केस क्या है। ये केस यूनियन बैंक ऑफ इंडिया से रिलेटेड है। इन केस वेयर एन ऑर्डर ऑफ सस्पेंशन वाज सर्व्ड अपॉन ए बैंक एम्प्लॉय only 10 months before the date of superannuation, the Supreme Court has quashed the disciplinary proceedings initiated against him after noting that he was shot to be victimized at the fag end of the unblemished career of 34 years. The appeal before the apex court was filed against the judgment of the division bench of the Allahabad High Court, affirming the order of the single judge dismissing the writ petition preferred by appellant seeking quashing of the charge sheet served on him pursuant to the disciplinary proceedings. The division bench of Justice Abhay Oka and Justice Augustine George held now at this stage it will be unjust to allow the respondent bank to resume disciplinary proceedings. Almost 6 years have passed since the superannuation of the appellant. Factual background of the case. The appellant was an employee of the Union Bank of India, respondent bank, where he served the approximately 34 years from 1984 to 2018. He was promoted to the post of Deputy General Manager in 2016 and was due to retire on June 30, 2019. The respondent bank suspended the appellant pending further disciplinary action, alleging that the appellant in his prior role as the regional head had adopted a very casual approach while sanctioning credit proposal in 16 accounts submitted by the mid-corporate Ghaziabad branch. It was alleged that he sanctioned huge limits to newly incorporated firms without ensuring proper due diligence by the branch or the processing officers. The appellant made multiple representations to the respondent bank requesting it to revoke his suspension. However, the same was of no avail. The appellant preferred a civil miscellaneous writ petition before the Allahabad High Court. The general manager submitted a personal affidavit justifying the delay in issuing the charge sheet as attributable to the matter being referred to the Central Vigilance Commission (CVC) in terms of Regulation 19 of the Union of India Officers Employee Discipline and Appeal Regulations 1976. The High Court quashed the suspension order. Another petition was filed by the appellant seeking quashing of the charge sheet, but the same was dismissed and the appellant was directed to cooperate in the inquiry. The appellant challenged the said order by filing a special appeal, but the division bench dismissed the same, holding that it was not necessary to seek the CBC advice before issuing the charge sheet. Aggrieved thereby, the appellant approached the apex court. The bench was of the view that it was not open for the bank to serve the charge sheet without receiving and considering the first stage advice by the CBC, as the respondent bank itself accepted the necessity of seeking first stage advice from the Central Vigilance Commission. The bench took note of the fact that only 10 months before the date of superannuation, an order of suspension was served upon the appellant. This was done after 34 years of the unblemished career service. Although it was necessary to take the first stage advice of the CBC, the advice was sought very late and 12 days before reaching the age of superannuation. A charge sheet was served upon the appellant without receiving and considering the CBC advice. This was despite the specific statement made by the executive director in the earlier petition on oath, which stated that the charge sheet would only be served upon receipt of advice from the CBC. Once the first stage advice of the CBC was called, it was the duty of respondent bank to consider the advice and then take a decision to serve the charge sheet. Thus, the actions of the respondent bank are malified and arbitrary. The appellant was sought to be victimized at the fag end of his unblemished career of 34 years. It said, as per the bench, the High Court committed a gross error by holding the Regulation 19 of the 1976 regulations was not mandatory. This issue was irrelevant as the bank had itself acknowledged that in the facts of the case, it was necessary to seek first stage advice from CBC. Moreover, no record was placed in the High Court to indicate that the CBC report had not been received. Thus, questioning the disciplinary proceedings, including the charge sheet and allowing the appeal, the bench held, although the appellant shall not be entitled to back wages and allowances, the respondent bank shall release all retirement benefits admissible on the basis that the appellant has superannuated as of 30th June 2019. The amount of retirement benefits due to the appellant in accordance with the law shall be paid to the appellant within 3 months from the today. This case title is the A.M. Kulshrestha versus Union of India and Union Bank of India and others. Thank you friends. Namaste.